Just a small point of statutory interpretation, Arlene. I noticed that reference to the two charter cities in Alberta having now a specific provision dealing with greenhouse gases. Does that perhaps either intentionally or non-intentionally decrease the likelihood that other municipalities created under the general legislation, which presumably doesn't have this power, does it decrease the likelihood that courts would be willing to find that power in them?
Okay, I just wrote it down. Expressio unius est exclusio alterus. Yes, the use of one expression excludes the use of another one. That is a rule of statutory interpretation. Can it be used between statutes? Oh, I thought of that. I wondered about that. But I think that the powers are broad enough, at least in Alberta, under our regular municipal legislation, so that the kinds of things that municipalities are doing and it would still be permissible. One of the things I wondered about is whether those express powers could be used when those express powers for charter cities could be used if in interpreting the express legislative tests, whether that would give perhaps those municipalities a better chance of their bylaws and plans or whatever might be being challenged of surviving one of those express legislative tests that our legislation has, since it's express legislation versus express legislation.
Hi, my question is for the person from Environment Canada. On the Greenhouse Gas Pollution Prevention Act, and I think it was the first presenter we saw this morning, he presented a slide which showed the distribution across provinces of how the prices escalate. And I just wonder if you could elaborate a little more on the rationale and how that's been determined.
Yes, sure. So one of the things that was elaborated throughout the first couple of years of the Liberal government.
Speak into the mic, please.
I'm sorry, everybody. Is this better? Okay, I'm just going to speak super loudly. Are we good? Okay. So one of what has been elaborated, or in the 2 years, when the Liberal government got in place, is that they wanted to make sure that whatever pricing mechanism that was established within the provinces, and that's something that the provinces and territories agreed upon when the Pan-Canadian framework was elaborated and signed on. Is that better? Oh, there you go. So the Pan-Canadian framework did establish that whatever systems that were established in the provinces and territories would need to have a progressive pricing. So it's not enough just to put a price, it needs to become more and more stringent as time goes by. So that's something that we've reflected within the Act itself also, notably in Part 1, which contains the fuel charge. So if you take a look at the various charges that has been established in Schedule 2 of the Act, you'll see that there are different charges depending on the type of fuel. And those charges do increase with the various years. So those prices have been established until 2022. And the same situation goes for the output-based pricing system. So the price that has been put on excess emissions does increase for 10 years per, $10 per CO2e tons per year. So right now we're in 2018, so the price is $20 per CO2e tons, and then in 2022 it's going to be $50. So there's this incremental there's this increase that has been established. And when we evaluate the systems and the systems in place in the provinces and the territories, which, by the way, this assessment will occur on a yearly basis. So we're going to make sure the government is going to take a look at these systems in place, and they're going to make sure that there's a similar type of progress in terms of pricing. So yeah, that's my answer.
Merci beaucoup pour vos présentations. I'm going to be greedy again and go for 3 questions, all for Madame Vachon. So just following up on what you've just said, so that yearly mechanism to ensure the prices are equivalent or that the provinces meet the federal standard, am I wrong in not having seen that in the Act itself, but it being sort of a process,
Yes, it is in the Act. It's in Schedule 2 and in Schedule 4 of the Act. So you can really take a look. It says, for example, fuel charge for year 2021, 2022. And you'll see if you compare with the previous year, you'll see that there's an increase for the various fuels, the type of fuels. So all of that was integrated into the Act, just in the back part of the Act, which is in the schedules. And that principle wasn't new, though. We've been, the federal government has been exploring that concept in the various documents that I referred to during my presentation. So that concept was elaborated on and it was consulted upon. And it was part of the basis of the Pan-Canadian framework, really, in terms of the mechanism, the pricing mechanism, because it's not enough to just put a price. In order to encourage everybody to reduce emissions, you really need this increase in price for it to be effective.
Okay, my question was not clear. What I meant is, how do we ensure that the province, let's say CEPA has equivalency agreements and a process to ensure equivalencies that is not perfect, but at least somewhat transparent and enshrined. Yeah. My understanding is this Act doesn't have such a mechanism.
It's not. No, you're right. The whole the assessment process I referred to in terms of the yearly assessment process. You're right. That's not directly in the Act. That's not embedded in the Act. That's something that the government committed to do to ensure the application of this Act. So we've already done that process during the fall, following September 1st. That was kind of the deadline the provinces and territories had to provide their plans. So we've already done our first assessment of provincial and territorial systems that are in place, or these systems that they do intend to put in place. And that process will happen on a yearly basis.
Perfect. Sorry if I can follow with my 2 other questions then. The first one is just a clarification. So you said what was planned is registration on the output-based
pricing system.
OPBS, yeah.
I know.
Would be for emitters over 50 kilotons.
Yes.
So am I right in assuming that's going to be in the regulation?
Yes, exactly. So that particular detail is not in the Act right now. As I've referred to it, that Act contains enabling authorities. So we haven't really provided the details in terms of exactly who's going to be a covered facility versus not. So yes, that detail will be provided for in the regulation, and I can make a promise it's going to be more complicated than I've just explained. So just to give you a sense, yes, it's going to be, we're saying that, okay, if you're above 50 kilotons, you're in, but you need to carry out an activity in a particular sector that we're going to name in the regulations. And also we're going to have an opt-in possibilities for the government will propose to have is proposing to have an opt-in for some specific sectors in terms of if they're emitting between 10 and 50. So anyways, all of those tiny details are going to be in the regulations, yes.
And then continuing on the tiny details.
Yep.
I believe there was a bit of a controversy in the media recently about maybe the fact that some large facilities would be exempted even if there wasn't necessarily a strong demonstration that they are trade exposed and that those measures are necessary. Could you comment on that? And désolé pour la patate chaude.
So really what we're trying to do here is put a signal in the economy. And whatever signal there is, studies have demonstrated that it is useful to help reduce greenhouse gas emissions. And part 2 was elaborated to ensure that there's no exodus, I want to say, for our various facilities that are established, and we don't want also to hinder economic development, I guess, with adding a price on carbon here. So I mean, the whole approach is going to be under review in 2020 and 2022. So there are going to be 2 reviews. So yes, we're putting this in place, but this is, yes, this is an act and we're going to have regulations, but I think there's going to be an ongoing assessment of, is this working or not? So that's my personal prediction. So we're not just going to let it lie there and just do its thing. We're going to take a look at it and make sure that it's actually working, and that whatever standards that are put in place, that they're stringent enough to ensure reductions of emissions, but that are not so cumbersome that they hinder development.
Thank you.
Ça fait plaisir.
Thank you all, Professor Kwasniak and Stewart and Ms. Vachon. My question, prompted by Professor Kwasniak's remarks about municipal authority. I'm from the U.S., and I'm going to be speaking tomorrow about U.S. law, and I'm having more epiphanies than I can describe as I listen to all of your presentations about what the future may be, once again, in the United States. With respect to preemption, what we in the U.S. refer to as preemption of state laws that are incompatible with federal, as well as municipal laws that are incompatible with state regulatory regimes. I'm curious if in Canada there is any doctrine similar to what in the U.S. is a preemption of lesser sovereignties, ordinances, bylaws, whatever. It's called the Commerce Clause. It comes out of the U.S. Constitution, and it's where a lesser jurisdiction's law or ordinance or bylaw is found to be unenforceable because it would require, and in fact, as a practical matter, does require different behaviors by businesses in different jurisdictions because of the different jurisdictions' different treatments of performance standards. These can be emissions performance standards, as well as, for instance, the famous case was a state that required that trucks have certain mud flaps on the back wheels of certain proportions that would require trucks coming in from out of state to change their mud flaps or violate the laws of the state they were going into that had these prescriptive mud flap proportion standards. Is there anything like this in Canadian law, either as it applies to municipal bylaws or to provincial laws that would be incompatible in the case of a municipal bylaw with a county standard or a state standard, or in the case of a provincial law incompatible with a federal one?
Well, I don't know, how much time do you have? No, that's really a huge question and a really big question. I mean, it's, I guess U.S. and Canada are somewhat similar, but also quite different too. We have federally, provincially, we have a lot of shared jurisdiction, and then we have the principle of paramountcy. If the federal government and the provinces both have power over something, and the federal laws will be paramount in a conflict. But with respect to provincial, like all municipal powers come from provincial laws, okay? And so anything that a municipality does has to be something within a provincial head of power under our Constitution. But there have been cases where it has been, the courts have found it's perfectly fine for municipal laws to be more strict than provincial legislation or what than provincial legislation or provincial authorizations, provided that the operator, the person who's subject to that bylaw, can comply with both at the same time. That was that Spraytec case I mentioned, the impossibility of dual compliance, and that had to do with the application of pesticides, but then again, it all really depends upon what is written into the provincial legislation. So that establishes a municipality. And if like in Alberta's legislation, there are rules somewhat like preemption that set out that if the province has regulated in an area or authorized something in an area, then the municipality doesn't say they don't have the right to pass a law. It says that their law will be inoperative insofar that there is a conflict. So it's more of a matter of what the legislation says. The province could delegate larger powers to a municipality, even than it does. So there are similar principles, but we use different language, and it's the whole discussion about constitutional differences between the U.S. and Canada, and even the differences between how municipalities operate in the U.S. and in Canada. We don't have home rule here, for example. You have home rule municipalities that really, I understand at least, can make their own laws independent of states, even if there is conflict. We have charter cities which have more powers than regular municipalities, but we don't have that kind of independence in our municipalities. I hope that at least starts to answer your question.